The courtroom was quiet, the kind of quiet that feels heavy, like everyone's holding their breath without realizing it. Sunlight slanted through tall windows, catching dust motes floating in the air. The wooden benches were worn smooth from years of nervous people sitting on them, waiting for their turn to speak, to be heard, or sometimes just to survive the system. At the front, behind a raised bench that looked more like a pulpit than a place for justice, sat the judge. He was in his late 50s, sharp-eyed, with a reputation for moving cases along quickly. Efficiency mattered to him. He believed the law was clear, and if people followed it, courtrooms wouldn't be so crowded. He tapped his pen against his notepad, already mentally preparing for the next case. Then she walked in. She was older, maybe in her late 70s, with silver hair pulled back in a loose bun. She wore a simple cardigan over a cotton dress, sensible shoes, and carried a worn leather folder clutched tightly to her chest. No lawyer walked beside her. No family members whispered encouragement from the gallery. She was alone. The bailiff called her case number. She stood slowly, carefully, as if every movement had to be measured. She stepped forward and stood at the podium meant for defendants. Her hands trembled just slightly, but her voice when she spoke was steady. "Your Honor," she began, "I'm here about the notice I received regarding my garden." The judge glanced at the file. It was a minor zoning violation, something about vegetable beds extending beyond the allowed setback from the property line. A technicality, really. The city inspector had cited her twice. She hadn't responded to the notices, so the case landed in court. "Ma'am," the judge said, not unkindly but with clear impatience, "you were sent 2 official notices. You didn't appear at the administrative hearing and you didn't file any response. That leaves me little choice," she nodded. "I understand, Your Honor. But I tried to explain." "Ma'am," he interrupted gently but firmly, "this isn't the time for explanations. The rules are clear. If you don't follow procedure, the court can't make exceptions no matter your age or circumstances." A few people in the gallery shifted. One young man in the back row frowned, glancing at his phone like he wanted to record something, but thought better of it. She didn't argue. She just stood there, quiet, her eyes downcast for a moment. Then she looked up again, not with anger, but with something deeper. Disappointment, maybe, or resignation. The judge sighed. "I'm imposing a fine of $300 plus $50 in court costs. You'll have 30 days to pay. If you can't, you'll need to request a payment plan through the clerk's office." She nodded again. "Thank you, Your Honor," and that was it. The gavel tapped once, soft, final, and she turned to leave. As she walked back to her seat, her steps were slow but dignified. No one clapped. No one spoke. But the air in the room had changed. It felt heavier now, like something important had just slipped through everyone's fingers without anyone noticing. Outside, the courthouse steps were warm in the afternoon sun. She paused for a moment, looking out at the street. The cars rushing by, people on their phones, life moving fast. She adjusted her cardigan, took a deep breath, and walked toward the bus stop. Back inside, the judge moved on to the next case, a landlord-tenant dispute. But something nagged at him. Not guilt exactly, more like a small, persistent itch in the back of his mind. He couldn't place it. Maybe it was the way she'd looked at him, not with fear or frustration, but with clarity. Like she saw something he didn't. Later that day, as he packed up his briefcase, his clerk handed him a new filing. "This just came in," she said. "It's from that woman, the one with the garden." He raised an eyebrow. "Already appealing?" "Not exactly," the clerk said, a curious note in her voice. "It's a motion for reconsideration, but you should read it." He opened the folder. What he saw surprised him. The document was typed cleanly, formatted properly, and filled with precise legal references. Not just general statements. Actual case law, statutes, even footnotes citing municipal code sections he hadn't reviewed in years. It argued that the original citation was invalid because the city failed to prove proper service of the second notice. It pointed out that under state law, procedural errors like that void the entire enforcement action. And then, near the end, in a paragraph written with calm authority, it noted that the so-called setback violation didn't even apply because her property was grandfathered under a 1978 zoning exemption that the inspector had overlooked. The judge read it twice. Then he leaned back in his chair, staring at the ceiling. He'd been wrong. Not just a little wrong. Completely wrong. He hadn't listened. He'd assumed. And in doing so, He'd penalized someone who clearly knew the law better than the city inspector, and maybe even better than him. The next morning, he called his clerk. "Schedule a short hearing. I want to revisit that garden case." The clerk didn't ask why. She just nodded. A week later, the elderly woman returned to the same courtroom. This time she wasn't alone. A few curious faces had shown up. Local law students who'd heard whispers about the motion, a reporter from the town paper, even the city attorney, looking uneasy. She stood at the podium again, same cardigan, same folder. But this time the judge didn't interrupt. "Ma'am," he said, "before we begin, I want to thank you for your motion. It was thorough." She gave a small smile. "I only wanted to be heard, Your Honor." "You will be," he said. "Go ahead," and she did. Not with drama or emotion, but with quiet precision. She walked through each point: service of notice, grandfathering rules, precedent from similar cases in neighboring counties. She spoke like someone who'd spent a lifetime thinking deeply about fairness, about how rules should protect people, not trap them. Halfway through, the city attorney stood up. "Your Honor, after reviewing the motion and the records, the city concedes the error. We move to dismiss the citation with prejudice." The judge nodded. Then he turned back to her. "Ma'am, I owe you an apology. I made assumptions. I didn't give your case the attention it deserved." She didn't gloat, didn't say "I told you so." She just said, "We all make mistakes. Your Honor, what matters is fixing them." The courtroom was silent again, but this time, the silence felt different. Lighter, full of respect. After the hearing, as people filed out, the judge watched her gather her things. He almost called out to her, but stopped himself. Some moments don't need words, but he made a note in his calendar. Next month's judicial training session. He'd add a new topic: listening beyond appearances. And as for her, she walked out into the sunlight again, this time with her head a little higher. Not because she'd won, but because she'd been seen. She didn't know it yet, but this small courtroom moment would ripple outward, touching students, neighbors, even judges in other counties. Not because of a dramatic showdown, but because one person refused to stay silent, and another chose to listen. And sometimes, that's how real change begins, not with a shout, but with a sentence spoken clearly in a quiet room, by someone the world had almost overlooked. Document Part 2, 1,400 words. A few days after the hearing, the judge sat at his desk late in the evening, long after the courthouse had emptied out. Rain tapped softly against the windows, and the only light came from his green-shaded lamp. He wasn't reviewing new cases. He was rereading her motion again. It wasn't just correct. It was elegant. Every argument built on the last like bricks in a well-laid wall. She'd cited cases from the 1980s that even seasoned attorneys forgot existed. She'd interpreted municipal code not as dry rules, but as living guidelines meant to serve people, not punish them for small oversights. And she'd done it all without a single emotional plea, just facts, logic, and quiet confidence. He leaned back, rubbing his temples. Who was she, really? The next morning, he asked his clerk to pull any public records connected to her address. Not out of suspicion, just curiosity. What he found surprised him even more. Decades ago, she'd graduated from law school with honors, top 5 in her class, but there was no record of her ever taking the bar exam in this state, or practicing law anywhere. Her name didn't appear in any legal directories. No firm, no court appearances, no disciplinary records. It was as if she'd vanished from the legal world the moment she stepped out of the classroom. Yet here she was, decades later, writing motions that would make a senior partner nod in respect. He couldn't shake the feeling that there was more to her story, but he also knew better than to pry. The law protected privacy for a reason. Still, something about her composure, her precision, it didn't come from reading a few pamphlets online. That kind of understanding came from years of study, reflection, maybe even sacrifice. Meanwhile, across town, she was back in her small house with the garden that had caused all the fuss. The tomato plants were ripening and the basil smelled sweet in the morning air. She watered them slowly, methodically, like everything else she did. Neighbors waved from their porches. Some had heard about the court case. Most didn't understand the details, but they knew she'd stood up to the city. And won. One afternoon, a young woman from down the street knocked on her door. She was studying pre-law at the local community college and had read about the case in the paper. Is it true you wrote your own legal motion? The student asked, eyes wide. She smiled. I did. Can I ask how? I mean, I'm just starting out and I get so overwhelmed by all the rules. Come in, she said gently. They sat at her kitchen table, sunlight streaming through lace curtains. She didn't lecture. She didn't show off. She just talked about how law isn't about memorizing every statute, but about understanding principles, fairness, intent, consistency. She pulled out an old notebook filled with neat handwriting, case summaries, and questions she'd asked herself over the years. I never practiced, she admitted, but I never stopped learning. The law is too important to ignore even if you're not in a courtroom. The student left hours later, clutching a borrowed copy of a legal reasoning textbook and a sprig of rosemary from the garden. For clarity, the older woman had said with a wink. Back at the courthouse, the judge made a decision. He couldn't undo his first ruling, but he could do better now. He scheduled a short formal hearing, not because the city hadn't already conceded, but because he wanted the record to reflect her arguments clearly. He wanted future clerks, future judges to see how a self-represented person, given a fair chance, could uphold the very spirit of the law. The day of the hearing arrived. This time the courtroom wasn't empty. A handful of law students sat in the back, notebooks open. The city attorney arrived early, looking less defensive and more respectful. Even the bailiff stood a little straighter. She entered alone again, but there was a quiet energy around her now. Not fame, just recognition. People saw her differently, not because she'd demanded it, but because she'd earned it through patience and precision. When she spoke, her voice was calm, but her words carried weight. She didn't repeat everything from her motion. Instead, she focused on one idea, that procedural fairness isn't a technicality, it's the foundation of justice. If the system doesn't follow its own rules, how can anyone trust it? The judge listened intently. No interruptions. No rushed gestures. Just genuine attention. When she finished, he didn't just dismiss the case. He went further. Your arguments, he said, highlight a recurring issue in municipal enforcement. Over-reliance on form over function. I'm directing the clerk to share your motion with the city's code enforcement training program. It's a masterclass in due process. A murmur ran through the room. This wasn't just about a garden anymore. It was about how the system treats ordinary people, especially those who don't have lawyers, money, or loud voices. After the hearing, the judge approached her near the exit. May I ask, why didn't you practice law? She looked at him for a long moment, then sighed softly. Life happens. I married young. My husband got sick. There were children to raise, bills to pay. Law school gave me tools, but life gave me different work. Still, I never stopped believing in what the law could be. He nodded. You've done more for justice today than many who wear the title attorney. She smiled faintly. Justice isn't about titles. It's about showing up. That evening, the local paper ran a short piece, not sensational, just factual. Elderly residents' legal argument leads to policy review. No photos. No dramatic quotes, but people talked. At coffee shops, at bus stops, in classrooms. The story spread not because it was flashy, but because it felt true. And in a small office downtown, a legal aid organization reached out. They'd been struggling to help low-income residents navigate housing and zoning issues. Would she be willing to consult? Just an hour a week? She said yes. The judge, meanwhile, started reviewing old cases, his own rulings from the past year. He looked for moments where he might have rushed, assumed, or dismissed. He found a few. He made notes. He began adjusting his approach, asking more questions, listening longer, pausing before speaking. He also did something unusual. He wrote a short internal memo to fellow judges in the county, not as a directive, but as a reflection. Today, I was reminded that wisdom doesn't always wear a robe or a suit. Sometimes it wears a cardigan and carries a folder full of truth. No one mocked it. In fact, several judges replied with their own stories, of janitors who knew court procedures better than interns, of grandfathers who spotted errors in eviction filings, of quiet citizens who understood rights more deeply than those paid to enforce them. Back in her garden, she pruned the pepper plants, humming softly. The fine had been canceled. The record cleared. But more than that, something invisible had shifted, not just in the courtroom but in how people saw each other. She wasn't a hero. She hadn't shouted or staged a protest. She'd simply refused to be invisible, and in doing so she'd reminded everyone that knowledge, dignity, and courage don't retire. They just wait for the right moment to speak, and when they do, the world leans in to listen. Document Part 3, 1,400 words. The story might have ended there, just a quiet victory, a corrected mistake, a lesson learned. But sometimes, when truth is spoken clearly enough, it opens doors no one expected. A week after the second hearing, she received a letter. Not from the city, not from the court, but from a small legal aid nonprofit downtown. They'd read about her case in the paper and heard through the grapevine how she'd helped a student understand legal reasoning over tea and tomato plants. Would she consider volunteering? They didn't have much to offer, just a desk, some coffee, and people who desperately needed someone who could explain the law without making them feel small. She thought about it for 2 days. Then she said yes. Her first morning at the office, she arrived early, carrying a thermos and a cloth bag with her old legal notebooks. The space was modest. Peeling paint, mismatched chairs, a printer that groaned like an old dog. But the energy was warm. Young staff members greeted her shyly, unsure what to make of this soft-spoken woman who'd apparently bested the system with nothing but logic and a library card. She didn't give a speech. She just sat down at the desk they'd cleared for her and asked, "Who needs help first?" That day, she met a single mother fighting an unfair eviction. The landlord claimed she'd violated her lease by having a cousin stay temporarily after a fire. The woman was terrified. She didn't understand the legal terms in the notice, and she couldn't afford a lawyer. Gently, patiently, the older woman walked her through it. She pointed out that the lease didn't prohibit temporary guests. She showed her a state housing guideline that protected tenants in emergency situations. And most importantly, she taught her how to write a clear, respectful response, citing the right rules, attaching proof of the fire report, and requesting a hearing. "You don't need to sound angry," she said. "You just need to be right and calm." By the end of the hour, the woman wasn't just armed with paperwork. She stood taller. She believed, for the first time, that the system might actually listen. Word spread fast in the legal aid office. Soon, others began lining up, not for legal representation. She made it clear she wasn't practicing law, but for guidance. A retired mechanic confused by a property tax dispute. A teenager trying to seal a juvenile record. An immigrant couple unsure if their landlord could demand extra fees. She never gave answers outright. Instead, she asked questions. What does the contract say? Have you checked the city code online? What would fairness look like here? She taught them how to think, not what to think. Meanwhile, the judge found himself thinking about her more often than he expected. He started noticing things he'd overlooked before, the way some defendants fumbled with forms, the way interpreters sometimes rushed through explanations. The way time pressure made him skip steps that seemed small but mattered deeply to the person standing before him. One afternoon, he visited the legal aid office under the pretense of reviewing community resources. But everyone knew why he was really there. He found her in a back room, helping a young man fill out a petition for expungement. She looked up and smiled. "Your Honor, I didn't expect to see you here." "I wanted to see where the magic happens," he said, glancing around at the stacks of binders, the hand-drawn flowcharts on the wall, the coffee-stained legal guides. She laughed softly. "There's no magic, just attention." They stepped outside for a moment, standing under a scraggly oak tree in the parking lot. He asked the question that had been weighing on him. "Why did you stay away from the law all these years? You clearly love it." She looked down at her hands, wrinkled, steady, still strong. "I didn't stay away," she said. "I just practiced it differently. At PTA meetings, I helped parents understand school policies. When neighbors got fined for broken sidewalks, I showed them how to appeal. Law isn't only in courthouses, it's in how we treat each other, how we hold systems accountable, even quietly." He nodded. "You could have been a judge yourself." "Maybe," she said, "but maybe I'm doing more good this way." Back at the courthouse, he couldn't stop thinking about that conversation. He began changing small things. He started allowing extra time for self-represented litigants. He asked clerks to provide plain language summaries of rulings. He even suggested the court create a navigator program, trained volunteers to help people fill out forms correctly, not as lawyers, but as guides. Some judges rolled their eyes. "We're not social workers," one muttered, but others listened, especially after they saw the results. Fewer missed deadlines, fewer appeals based on confusion, fewer people showing up to court looking lost and afraid. Then came the invitation. The State Judicial College was hosting a training for new judges. They asked him to speak about courtroom efficiency. He agreed, but only if he could share part of his talk with someone else. He called her that evening. "Would you be willing to speak to a room full of judges, just 10 minutes, about what it's like to stand on the other side of the bench?" She was silent for a long moment. "I'm not a public speaker." "You don't have to be," he said. "Just be yourself, that's enough," she agreed. The day of the training, she wore the same cardigan but with a small brooch, a gift from the legal aid team. The room was filled with judges in crisp suits, some barely out of law school, others with decades of experience. They sipped coffee, chatted about rulings, scrolled through phones. Then she walked in. The room grew quiet, not out of obligation, but curiosity. They'd heard rumors. Now they saw her. She didn't use a microphone. Her voice was soft, but every word landed. "I've never worn a robe," she began, "but I've spent a lifetime watching how the law feels to those it's supposed to serve. And I've learned this. When someone walks into a courtroom alone, they're not just scared of losing. They're scared of not being understood." She spoke about the weight of silence, the moment when a judge looks at you like you're wasting their time. She described how a single phrase, "You should have known better," can make someone shut down forever, and how a simple "tell me more" can restore dignity. She didn't blame anyone. She simply told the truth. When she finished, there was no applause at first, just stillness. Then one judge stood, then another. Soon the whole room was on its feet, not for a performance, but for a reminder. Afterward, several judges approached her. One asked for book recommendations. Another admitted he'd dismissed an elderly defendant just last week and now regretted it. A young judge, eyes glistening, said, "Thank you for reminding us why we took this job." She went home that night tired but peaceful. Not because she'd changed the system, she knew that took generations, but because she'd planted seeds. And seeds, given time and care, grow. In her garden, the tomatoes were heavy on the vine. She picked a few, wrapped them in newspaper, and left them on the legal aid office doorstep the next morning with a note. For clear thinking. And somewhere in the courthouse, a new memo was being drafted. This one proposing mandatory bias and accessibility training for all court staff. Change, she knew, rarely roars, it whispers. And if you're quiet enough to listen, you can hear it growing. The judge didn't sleep well that night. Not because he was troubled, but because his mind wouldn't stop turning over what he'd seen, what he'd heard, and what he'd missed for so long. He'd spent years believing that fairness meant treating everyone the same. But now he realized, true fairness sometimes means seeing people differently, not to favor them, but to understand them. He sat at his kitchen table before sunrise, coffee steaming in a chipped mug, and opened a fresh notebook. On the first page he wrote, "Assumptions are the enemy of justice." It wasn't poetic. It was a warning to himself. By mid-morning he was back at the courthouse, but something had shifted. He greeted the bailiff by name, asked the clerk how her daughter's recital went, and when a nervous teenager appeared for a traffic hearing without a lawyer, he didn't sigh or glance at the clock. He leaned forward and said, "Take your time. Tell me what happened." The change was small, almost invisible to outsiders, but inside the courtroom it felt like a door had opened. Meanwhile, she returned to her quiet routine, tending her garden, volunteering at the legal aid office twice a week, and occasionally meeting with students who'd heard about the woman who out-argued the system. She never called herself a teacher. She preferred someone who remembers what it's like to be confused, but the ripple from her courtroom moment kept spreading. One afternoon, a reporter from the regional news station showed up at the legal aid office, not with cameras blazing but with a quiet request. "Would you be willing to talk about how ordinary people can navigate the legal system without a lawyer?" No sensationalism. No gotcha questions. Just a human story. She hesitated. She didn't like attention. But then she thought about all the people who stayed silent because they felt powerless, and she said yes. The interview was filmed in the garden, late in the day when the light was golden. She spoke about rights, yes, but more about respect. The law isn't a wall, she said, plucking a leaf from a basil plant. It's a path, and everyone deserves a fair chance to walk it, even if they're barefoot. The segment aired on a slow Tuesday evening. It wasn't flashy, no dramatic music. Just her voice calm and clear, talking about how to read a legal notice, where to find free resources, and why showing up, even scared, is half the battle. Within days, calls to the legal aid office doubled. Not all could be helped, but every caller was treated with patience. And many said the same thing. I saw that woman in the garden, and I thought if she can do it, maybe I can too. Back at the courthouse, the judge noticed something else. Fewer people were showing up unprepared. More brought printed copies of city codes. Some even cited case names, usually mispronounced but with clear effort. It wasn't perfection, but it was participation, and that mattered. Then came the letter from the State Judicial Council. They'd heard about his courtroom changes, the extra time, the plain language summaries, the new Navigator pilot program. They wanted to know, could this model work elsewhere? Would he present it at the annual judicial conference? He agreed, but only if she came with him. At first she refused. I'm not part of the system, she said. I'm just someone who lives in it. But you see it more clearly than most of us, he replied. That's exactly why they need to hear from you. After a long pause, she said yes, on one condition. No titles, no introductions that make me sound like a hero. Just let me speak as myself. The conference was held in a downtown hotel, all glass and polished floors. Judges in dark suits milled about, sipping coffee, swapping stories about tough rulings and tight dockets. When she walked in, cardigan, sensible shoes, no entourage, more than a few eyebrows lifted. But when she took the small stage beside the judge, the room stilled. She didn't give a lecture. She told a story. She spoke about the first time she read the Constitution, not in law school but as a teenager, sitting on her porch after her father lost his job, and their landlord tried to evict them without cause. She'd stayed up all night reading about due process, not because she wanted to be a lawyer, but because she wanted to protect her family. I learned then that the law isn't just words on paper, she said. It's a promise. And promises only mean something if everyone can reach them. She talked about the shame many feel when they don't understand legal forms. The fear of sounding stupid in court. The way a rushed hearing can feel like being erased. And yet, she added, so many people still show up. They dress their best. They bring their documents in grocery bags. They stand straight even when their knees shake. That's not weakness. That's courage. When she finished, there was no standing ovation, just a deep, thoughtful silence. Then one by one, judges came up to her, not to praise her, but to ask questions. How do we make forms clearer? What's the one thing we should stop doing in court? How do I know if I'm really listening or just waiting to talk? She answered each one simply, honestly. No jargon, no performance. Just human to human. That evening, over a quiet dinner in the hotel restaurant, the judge finally asked the question that had been in his heart since the very beginning. Do you ever regret not practicing law? She stirred her tea slowly. Regret? No, but I do wonder sometimes. If I'd stayed in, would I have become someone who forgot what it felt like to stand alone in a courtroom? Maybe stepping away kept me honest. He looked down at his plate. I think I needed to meet you, he said quietly. Not just to fix a mistake, but to remember why I put on this robe in the first place. She reached across the table and touched his hand, just for a second. You didn't need me. You just needed to pause long enough to hear yourself again. The next day, the Judicial Council announced a new statewide initiative, Courts That Listen. It would include training on implicit bias, simplified legal forms, and support for self-represented litigants. And at the judge's suggestion, they created an advisory role for community voices, starting with one quiet woman from a small town with a garden full of tomatoes. She didn't want a title, so they didn't give her one. Instead, they gave her a seat at the table. On the train ride home, she watched the countryside blur past the window. She thought about all the people who'd been told they didn't belong in legal spaces because of their age, their income, their education. She smiled softly. Belonging wasn't about permission. It was about presence. And she'd shown up. Back in her kitchen that night, she wrote a note to the young student who'd first knocked on her door. Keep asking questions. The law needs people like you. People who care more about people than rules. She sealed it, tucked it in an envelope, and placed it by the door to mail in the morning. Outside, the crickets sang. The garden slept under a blanket of stars. And somewhere in courthouses across the state, judges were pausing just a little longer before speaking, listening not just to the words, but to the person behind them, because sometimes the most powerful revolutions begin not with a gavel but with a question. Tell me more. Months passed. Seasons turned. The garden that had once sparked a courtroom battle now overflowed with late summer squash, beans climbing trellises, and sunflowers nodding in the breeze. Life settled into a rhythm, not quiet exactly, but steady. And in that steadiness, something remarkable grew. Not just vegetables, but trust. She still volunteered at the legal aid office, though now she didn't sit alone at a desk. Young people gathered around her like students around a wise elder, not because she claimed to be one, but because she made space for them to think out loud. She never gave answers. She asked better questions. What do you think the rule is trying to protect? Who benefits if this goes your way? What would fairness look like to someone on the other side? One afternoon, a teenager came in, eyes red from crying. He'd been cited for a minor offense, a misunderstanding with a school security guard, and feared it would ruin his chance at college. She listened without interrupting, then handed him a worn copy of the municipal code. Start here, she said. Read it like a story. Who's the hero? Who's being protected? Then ask yourself, where do you fit in? By the end of the hour, he wasn't just calmer, he was curious. He left with notes, a plan, and something even more valuable: hope. Meanwhile, the judge had changed too, not in dramatic ways, but in daily ones. He no longer rushed through dockets like they were chores. He made eye contact. He said thank you when someone brought paperwork in order. He even started keeping a small notebook where he jotted down things he'd learned from people in his courtroom. A veteran's tip about VA housing rules, a grandmother's explanation of informal childcare arrangements, a delivery driver's insight into how traffic fines hit gig workers hardest. He'd realized something important. Justice isn't just handed down. It's built, brick by brick, conversation by conversation. Then came an invitation neither of them expected. The state's Judicial Training Academy asked them to co-lead a session for new judges. Not as speaker and guest, but as partners. We want them to see what real collaboration looks like, the director said. Not just law from the bench, but wisdom from the community. They agreed, but only if the session felt like a conversation, not a lecture. The day arrived. The room was filled with freshly appointed judges, many still in their 30s, eyes bright with idealism but also uncertainty. They'd studied case law for years, but few had stood in line at a housing office or tried to read a legal notice while working 2 jobs. She walked in first, carrying a basket. Not files, fresh zucchini and a jar of homemade pesto. For lunch, she said with a smile. Gardening keeps me honest. You can't fake a tomato. Laughter rippled through the room. The tension eased. The judge began by admitting his mistake, the rushed hearing, the assumption, the fine he'd imposed without truly listening. He didn't excuse it. He owned it. I thought I was being efficient, he said, but I was being lazy. And laziness in a courtroom hurts people. Then she spoke, not about law, but about dignity. When you walk into a courtroom alone, she said, you're not just afraid of losing your case. You're afraid of being invisible, of being seen as a file number, a problem to clear off the docket. But every person who shows up is carrying a whole life. Worries, hopes, people counting on them. If we forget that, we've already failed. She didn't quote statutes. She told stories about the single dad who missed a hearing because his bus broke down, about the elderly man who didn't know he could ask for an interpreter, about the young woman who thought default judgment meant she'd done something morally wrong. And yet, she added, they kept coming back, not because they loved the system, but because they believed somewhere deep down that fairness was still possible. One new judge raised a hand. But how do we balance that with heavy caseloads? We're told to move fast, she nodded. You don't need more time. You need better attention. One clear question can save 10 minutes of confusion. A kind tone can prevent an appeal. Listening isn't slow, it's efficient in the deepest way. After the session, no one left quickly. They lingered, asking questions, sharing their own doubts. One judge admitted he'd almost dismissed a self-represented litigant that morning, until he remembered her words about invisibility. Another asked for a copy of the plain language form she'd helped design. As they packed up, the judge turned to her. You've changed more minds today than I could in 10 years. No, she said gently. I just reminded them of what they already knew. You're the one who gave it space to grow. Later that week, something small but meaningful happened. The city council voted to revise its code enforcement procedures, adding clearer notices, translation options, and a grace period for first-time violations. The motion cited her original court filing as inspiration. She didn't attend the meeting. She was in her garden, teaching a neighbor's child how to tell when a cucumber is ready to pick. Gentle squeeze, she said. Not too soft, not too hard. Just right, the child grinned. Like Goldilocks. Exactly, she laughed. Even the law should be just right, not too harsh, not too loose. Fair. Back at the courthouse, the judge did something unusual. He invited her to sit in on a training for new bailiffs and clerks, not as an expert, but as a citizen. She spoke about how a simple good morning or let me help you find that form could change someone's entire experience of the justice system. Afterward, a young clerk approached her, eyes shining. My grandma used to say the law should serve people, not the other way around. I forgot that. Until today, she patted the clerk's hand. Then remember it for both of you. Time moved on. The story never made national headlines. There were no viral videos, no best-selling books. But in quiet ways, it took root. The Legal Aid Office launched a community law circle, monthly gatherings where neighbors could ask questions, share experiences, and learn their rights together. She helped design it, but never led it. It's not mine, she'd say. It's yours. And the judge? He kept his notebook, filled it with lessons from the people who passed through his courtroom. Years later, when he retired, he donated it to the Judicial Academy with a note on the first page. The best teachers don't wear robes. They wear cardigans, carry grocery bags full of documents, and never stop believing in fairness. One crisp autumn morning, the two of them met again, not in a courtroom, not at a conference, but at a small cafe near the courthouse. They shared coffee and a plate of scones. No agenda, no audience. Just two people who'd learned, through an unlikely collision of garden soil and legal code, that justice isn't a distant ideal. It's a practice. I still get nervous before court, she admitted. And I still catch myself making assumptions, he replied. But now I pause. They sat in comfortable silence for a while, watching people hurry past on the sidewalk. Students, workers, parents with strollers. Ordinary lives full of quiet struggles and unseen strength. Before they left, he asked, Do you think we made a difference? She looked out the window, then back at him. Not we. You listened, I spoke. That's all anyone can do. But when listening and speaking meet with respect, that's where change begins. She walked home slowly, stopping to admire the turning leaves. In her pocket was a note from a student who'd just passed the bar exam. You taught me that law isn't about winning. It's about making sure everyone gets a fair chance to be heard. I'll carry that with me always. That night she watered her garden one last time before the frost. The summer's bounty was winding down, but the soil was rich, ready for next year, and somewhere, in courthouses and community centers and kitchen tables across the state, people were still showing up, scared sometimes, unsure often, but never silent. Because they'd learned something simple, powerful, and true. Your voice matters. Your story counts. And fairness isn't given. It's claimed, gently, firmly, by those who refuse to be overlooked.